Hello and welcome to the latest in this Landmark Chambers video series on an introduction to judicial review. I'm David Blundell, KC, and I'm here today with my colleague Andrew Byass to talk to you about defending judicial review claims. In broad terms, we've got two main themes we wanted to discuss. So first of all, we wanted to look at the different stages of a judicial review claim and how to defend each one. And then secondly, we want to talk to you about some of what we think are the golden rules of defending judicial review claims. So looking first of all at the different stages of defending a judicial review claim, the judicial review process as a whole, of course, does come as a multi-stage process, a multi-stage procedure. You have obviously the pre-action process to begin with, regulated by the pre-action protocol. You then have the application for permission, at which point you have to consider as a defendant lodging summary grounds of defence and acknowledgement of service. If permission is granted, then you have the stage at which you have to consider putting forward detailed grounds of defence and evidence. And then finally, prior to a substantive hearing, you have the usual submission of skeleton arguments. I think it's fair to say one size does not fit all for all those different stages, and there are a number of different considerations to bear in mind when defending each one of them. So with that in mind, Andrew, would you like to start by considering the pre-action response?
Yes, so the first thing you're likely to encounter is a pre-action letter. And if you're the defendant, it's a real opportunity that you should take. Pre-action letters are your opportunity to really succinctly and robustly deal with the grounds that are advanced in a letter that seeks to try to stop the claim completely, ideally, or at least knocks out grounds. Certainly in my experience, pre-action letters when issued can sometimes be fishing expeditions. They can sometimes include grounds that have varying merits. And if you can do a really good job, at least with some of the grounds in terms of knocking them out, then you are going to make your job easier when it comes to the claim being issued. I do have experience of a claim being issued, a pre-action letter being sent, and the pre-action response killing the claim effectively. There was a legal approach that was taken, which we were able to point out was flawed, and that just resulted in the claim not appearing at all. But the most likely outcome is that you'll at least narrow the grounds of claim. And the work that you do is going to assist you when it comes to summary grounds of defence as well, because you can borrow that on. But certainly at both the pre-action stage and in summary ground stage, one of the key things you should be thinking about is knockout blows.
That's absolutely right, Andrew. And when you're looking for knockout blows, I think some of the key points to bear in mind at that stage will be, for example, arguments about timing and delay. So has somebody unjustifiably delayed in commencing a claim? Are they outside the outer 3-month period? Similarly, does the claimant have standing according to the standing test? And there's been some relatively recent case law developments in that field in the High Court. Equally, is there an alternative remedy? In my experience, that can be quite an important point to raise at the pre-action stage. And like Andrew, I've had some experience of successful pre-action responses, certainly raising alternative remedies issues which have knocked out claims at that stage. So think carefully about whether there might be, for example, a statutory review process or a statutory appeal process that needs to be considered. Similarly, there have been recent developments in the court's case law, for example, Supreme Court level in particular, about the relatively limited scope of judicial review proceedings. So think carefully about whether a claim is actually really a merits-based challenge rather than, as judicial review has to be, focusing on the legality of the decision-making process. So again, that can be an important point to seek to draw out and emphasise at the pre-action stage.
And we'll come on to talk about it with the golden rules, but the importance, I think, David, of the knockout blows as well is that you've got to bear in mind that you've got a judge dealing with paper applications, no doubt dealing with multiple paper applications in a day. And if you can make the job easier for a judge, much to your benefit. The other thing to think about when you're at the pre-action stage or the summary ground stage is whether or not there's arguments that you might be able to make that even though there may have been an error, the outcome would highly likely have been the same. And that's quite important because of changes that have been made to the Supreme Court Act, which requires courts or judges, when considering permission, when asked by defendants, to consider whether or not the outcome would have been highly likely to have been the same. And if that's the outcome, or if that's the decision that's made, to refuse permission on that basis. So in appropriate cases, you will be wanting to think about making those sorts of arguments, looking to see whether in the alternative you might say, well, we say there's no error, but even if you find that there is, the outcome wouldn't have been any different. And so really, there's no material error here to be concerned about, and refuse permission on that basis as well. So when it comes to drafting your summary grounds of defence, you're thinking about those knockout points. You're thinking about whether you can make arguments about it's highly likely that the outcome would have been the same. Your summary grounds, though, should ideally be brief and to the point. In some cases, it may be appropriate simply to append your pre-action letter. If that's a robust and thorough job, you may be looking just to do that. Certainly, the work you've done with the pre-action letter can be converted typically into that sort of short and succinct summary grounds of defence that the court will appreciate, particularly in that context of having lots of paper applications to deal with in any particular day.
I think that's a really important point, Andrew, about making sure that any response at the summary ground stage is really punching to the point. And again, as Andrew has indicated, we'll come on in the golden rules section in a moment to deal with some of these thematic issues. But of course, at the stage at which a judge is reading your initial defence through the summary grounds to a claim, he or she will already have read the claim form, the particulars, the grounds of claim rather, any evidence that goes with them. And so your response needs to build on that and be really punchy and to the point. One issue that occasionally comes up at the summary ground stage is whether or not to file witness evidence. That is, relatively speaking, a rare approach. Certainly in my experience, I can think of relatively few claims where I thought it appropriate to file witness evidence. However, it can be necessary on occasions, perhaps where there is a factual point relevant to the merits of the claim, which needs to be emphasised absolutely at the outset, and which will be determinative in resisting the grounds that are being advanced. But I think overall, filing witness evidence at the summary ground stage is really the exception rather than the rule, and that's reflected in the fact that the CPR only really makes reference to filing evidence at the detailed ground stage. So consider the need to file witness evidence, but if possible, avoid that. And given that time is short, of course, when you're going through that process, you do have to move quickly. If it looks like you're going to be coming up against a 21-day limit, you will need to think very quickly indeed about applying for an extension of time.
Certainly when you get to the detailed ground stage, the next stage in the process, if permission is granted, you will want to be considering more carefully the question of whether to file witness evidence. It's not necessary. In many cases, you won't need witness evidence at all. You'll be able to rely upon the documents that are available to the court or to your client. And in many cases, a claim for judicial review is going to involve pure matters of law. And so you're not going to need a witness statement demonstrating or helping you assisting you in making the points that you want to make in your detailed grounds of defence. If you are going to put witness evidence in, detailed grounds, you've got 35 days from the grant of permission to put it in. It's a vanishingly short period of time. It can go very quickly. And particularly if you are needing to gather witnesses from different departments or different parts of government or from different parts of your client body, you're going to need to move quite quickly. If evidence is provided, if you do gather evidence, ensure that you address it in your detailed grounds of defence. It's your opportunity to deal with those factual matters, flesh out the points that you made in your summary grounds of defence, and set out your stall so far as the evidential background is concerned, in order to put yourself in the right place when it comes to making your legal submissions. And that's important when you come on to the next stage, because the next stage is the claimant's skeleton argument and then your consideration of your skeleton argument and response.
That's absolutely right. And in fact, just picking up on a couple of points, Andrew, you've just made, I would really highlight the importance of trying to match the evidence that you're filing with your detailed grounds, and indeed then later on with your skeleton arguments. It's amazing how often you'll see swathes of evidence lodged with detailed grounds of defence. to which the detailed grounds make barely any reference at all, and to which the skeleton argument then makes very little reference. And I think that can leave judges thinking, well, why on earth has this material been filed? It's just a waste of time. So it's really important always to draw back your legal arguments to the evidential material that you've filed alongside the legal documents. So once you get to the skeleton stage, of course, you are building at that point on what has gone before. So bear in mind what I've just said about matching up the evidence to the legal arguments you're making then. Bear in mind also one of the things that Andrew mentioned before about the importance not only of trying to demolish your opponent's case, but also properly setting out your own case. Your skeleton is your chance to set the narrative for your case, and you should really grasp that with both hands. You need to make sure that all the points you want to make are made there, but at the same time, you need to avoid getting bogged down in too much detail for the skeleton. You can properly make reference to the other materials and the documents that are being filed without verbatim citing them. That's obviously an issue which has come up again in some of the critical comments that the courts have made recently, about sorts of pleadings that are sometimes produced in judicial review claims, and that's a very important point. So remember, your skeleton is your, in a sense, most important advocacy tool in preparation for the hearing. Judges do read skeletons very carefully and in full these days, and they expect them to be well drafted. It is your opportunity to land your first blow in the immediate run-up to the hearing, and to try and ensure that the court is on side with you by the time your opponent stands up to make their case. So that's what we want to say about the first of the two key themes we wanted to cover this morning. Next, I'd like to move on to looking at some of the golden rules that Andrew and I thought were important to bear in mind generally when you're considering how to defend a judicial review claim. And I think the first point I'd make, first golden rule I'd set out, which really builds on some of what we've said already, is that in any document you're drafting for the court, whether it's the summary grounds, the detailed grounds, the skeleton, even to an extent, I think the pre-action protocol response as well, it's really important, a really good idea to start with a very punchy summary of your client's position. And bear in mind that when a judge is reading the documents, he will be coming to the defendant's documents second. He will have read whatever document is relevant for the particular stage, be it the grounds of claim or the skeleton from the other side first, and we'll have an idea of what the claim's about and what's being argued. The start of your summary grounds or detailed grounds, skeleton argument, is your chance to say, no, the claim is actually about this, and this is the critical answer that you need to bear in mind. So I always try and start my documents with a short paragraph saying the grounds are without merit for these three reasons, 1, 2, 3, something like that. I think that's important in trying to get the court on side with you as soon as possible, and also to persuade the court that you've got a way through the case that it can be confident you're going to follow from the beginning right through to the end.
I think the point that you make there, David, about being aware that your pleading, your documents are going to be read after the judge has read the claimants is a really important one, because you need to think about where you're adding value. And that applies no matter who you are within a legal team. If you're the instructing solicitor, you're often much closer to the client than the advocate and the barrister. And so your role and your critical analysis of the pleading that you get from counsel is really important. And to look at it and to think about what you know and whether or not the key points that you're aware of from the factual background come across and read into what is being said in response is really important. So bear that in mind in terms of the role of the legal team as a whole. It's a joint effort, undeniably. And just remember also that your documents have ultimately got to do two things. We touched on this before. They've got to demolish the claimant's case, but they've got to also set out your case. And those two things can be closely aligned sometimes, but they are distinct. And you do want the judge to come away from reading your pleadings and seeing your defense, knowing not just why you consider the claimant's case is unfounded, but why it is and what path the judge should follow to reach the correct conclusion. And that's ultimately what you're trying to do. You're trying to give a court or the judge the path through to the result you want. So think about those two things fundamentally when it comes to drafting.
I think that's really important, Andrew. And I think another way of looking at that is that very often when you see both claims being put forward and also defended, the different aspects of a claim, the different arguments can seem very discrete. It seems as if they perhaps don't always have a coherent connection. What's really critical to do is to try and introduce a narrative to the proceedings, and you want it to be your narrative, which is why doing both those things, as Andrew says, is so important. But equally, when you're doing that, don't lose sight of what I think of as the beginning, the middle, and the end. So the beginning, preliminary issues, and maybe really punchy knockout points that can be taken as preliminary issues in a case. Again, the sorts of points I flagged at an early stage of the talk when I talked about timing, alternative remedy, standing, inappropriate approach to merits, those kind of issues. Secondly, as regards the middle, by that I mean interim issues. In all stages of defending a judicial review claim, you may have to deal with issues of interim relief, particularly at pre-action and summary grounds stage. So make sure you're fully focused on them. You'd be amazed by how often defendants and those representing them will forget to deal with an application for interim relief that's been pleaded in a claim form. Do be careful about that. And then finally, a point that in my experience you often hear judges complaining that counsel haven't dealt with properly, relief. It's a point really for claimants to think about in particular when they're formulating a claim, but equally for defendants to think about very carefully when defending a claim. What's the relief that's being sought? Is it inappropriate? Can it even be granted in a claim like the one you're defending? Equally, if it looks like the claim may well succeed, do you want to be taking a point about granting a different form of relief if the claim succeeds? That can be quite a tricky line to take, but equally a very important one. You have to be realistic about your prospects. And if you think that you're going to be realistically in the position at the end of a claim of having to deal with relief, make sure you set the groundwork in the early documentation as to why relief which is more convenient and more appropriate for your clients is relief that's finally granted. So while you're setting up that narrative, while you're developing the narrative, make sure you don't lose sight of those important stages as well.
It's an important point on relief, because one of the overarching things or fundamental things one should never lose sight of is that sometimes the best form of defense is conceding a point. Or conceding a claim. And the earlier you do that, the better it is in terms of costs for your client. But making pragmatic concessions as you go, thinking about relief, as David says, is one of the more important things you need to think about as you go proceed with the claim.
I think Andrew's point is an excellent one really to finish with as well. Concession can be very important. It may well be that you're faced with a massive claim, a claim with lots and lots of grounds. And it may be that although some of them you can defend from the very earliest stage, others, being realistic, are going to be granted permission. And indeed, you may be in the position of some clients actually wanting to have a particular legal point ventilated, perhaps a point they're coming across very often. Maybe the case in question is a good one on the facts to test it. Always think strategically about whether you can give a little to win a lot. Can you perhaps make a small concession? Can you perhaps concede permission on one or 2 points, but make it clear you're going to defend them substantively very robustly at an earlier stage, and thereby make you and your client appear very reasonable and realistic. Again, amazing the credit that you can get for that sort of realistic and proportionate approach to the litigation you're faced with. So do bear in mind those kind of considerations as well. Well, thank you very much indeed.
Thank you, David,
for that. And thank you very much indeed all for listening. We hope that was helpful.